Good morning. My name is Barbara Fuller, and as chair of the board, I welcome you to this September 17th, 2024 working session of the Washtenaw County Board of Road Commissioners. Our office coordinator, Aaron Smith, will describe how our working sessions operate, how to access the agenda packet, and how people may participate remotely. Aaron.
Thanks, Chair Fuller. There are multiple ways to make public comment during today's working session, whether you're joining us in person or virtually. If you're here in person and would like to make comment, please fill out the sign-in sheet now. If you're joining us virtually, we will ask you to raise your hand at the appropriate time in the agenda. If you're joining us virtually and are experiencing technical issues with audio or video during the meeting, submit a comment in the chat feature and our communications manager will help you troubleshoot. If you would like closed captioning during the meeting, you'll have to manually change your settings, click on the captions button and select show captions. The audio and video of this meeting is being recorded, and a link to the recordings will be posted to wcroads.org in the next few days. There are printed copies of today's meeting agenda on the table near the front door, and it is also posted on our website. And now I'll turn it back over to Chair Fuller.
Thanks, Aaron. I now call this September 17th, 2024 working session to order and ask Aaron to call the roll.
Chair Barb Fuller.
Present.
Vice Chair Rod Green.
Present.
Commissioner Gloria Yamas.
Present.
And Commissioner Joanne McCullum.
Present.
I just would like to note that Commissioner Jeff Smers is absent today.
He has an excused absence.
Excuse.
As of late last night.
And then the following directors are in attendance: Managing Director Matt McDonald, our Director of Engineering and County Highway Engineer Brent Schleck, our Director of Operations Adam Leip, and Director of Finance Dan Ackerman.
Thank you, Aaron. We'll now move on to public comment. This is the time set aside on the agenda to receive comments from the public. This is not intended to be a period for dialogue. Each person will be allotted 3 minutes to address the board, and Aaron will explain how people may be recognized to offer comments.
Since this is a hybrid meeting with both in-person and virtual attendees, we will take turns between those attending in person and virtually. For our virtual attendees, we have provided some instructions on the screen on how to participate and make comment. If you're attending this meeting virtually and would like to make comment, please raise your hand now. If you dialed into the meeting from your phone, you can raise your hand by dialing *9. Our communications manager will unmute virtual participants with raised hands one at a time and will announce your username or the last 4 digits of your phone number when it is your turn to speak. And then please share your name and address before beginning your comments. And then for our in-person attendees, we will start with those who signed up on the sign-in sheet as you walked in. If you didn't sign in, you're still welcome to make comment. Our communications manager will notify you when it is your turn.
Thank you. We will proceed now with our agenda, and I will turn the gavel over to Matt to take us in the agenda.
Good morning, Commissioners. First up on the agenda is the review of our bylaws and parts of the Open Meeting Act. With us this morning is Dan Troika and Stephen Postma. They're from Conlin, McKinley, and Philbrook, our attorneys, and they have drafted a revised bylaws that we're going to kind of walk through. So come on up to the podium and step us through some of the revised bylaws. Does everyone have a copy of the written ones? Okay.
Good morning, everybody. It's good to see you this morning. I'm Dan Troika. I've met with you many times before. As you might know, I've been doing condemnation work and ancillary work for the Road Commission since about 2005. I'm privileged to have with me Stephen Postma. I brought him with me and I've asked him to be available to speak with the commissioners. He was city attorney for the city of Ann Arbor for 18 years. About a year and a half ago, we were successful in recruiting him to our firm. That helps to expand our municipal practice, and it helps us to serve you better. City of Ann Arbor, for better or for worse, has had to deal with the Open Meetings Act more than we have, and therefore he's had experience at the cutting edge of what does this act really mean? How do you stay within the 4 corners of it, which, as it turns out, is not a simple issue. So a few weeks ago, we were asked to go through the bylaws and propose revisions. There are 2 basic types of revisions that we have recommended to the board. One is to conform the bylaws to what our practice actually is. So there were a few places where maybe the way we did things was departing from what we actually had in our bylaws. The more significant substantive changes are to comply with the Open Meetings Act. And there, as an attorney, it's a bit of a minefield. There are lots of confusing provisions of that act you may have all the good intentions in the world, yet when it comes down to specific questions of compliance, it's actually quite difficult. Since my firm last prepared the bylaws, there has actually been reasonably significant changes in the case law. From an attorney's perspective, the way this happens is we read the act, we give you our best interpretation of it. Then at some point, a court pronounces what something means. Well, maybe we were right, maybe we were wrong. But once we get pronouncements from the courts of appeals or the Supreme Court, we have to go back and check and make sure that we are in fact complying with what the law requires. The Open Meetings Act, Freedom of Information Act, together are what we call sunshine laws. They serve a very important function. They allow the public, they allow the citizens, they allow the people we serve to see what we do. That's certainly a good policy. We all support that. We as attorneys, encourage full compliance, both in the letter of the law and the spirit. And yet there are circumstances where how do you address a certain issue? There's not a simple answer. So we're doing our best in these revisions to identify and help to refine our rules for those areas in which the law is less than clear or there have been recent developments. That's really mainly the guiding principle here. Beyond that, we did not try to rewrite the bylaws. If it's not broke, don't fix it. We think they work well. So we limit ourselves to the two categories I mentioned. What I'd like to do, as it probably just makes sense, is to go through the draft in order rather than try to mix it up. So I believe we have up there the current draft. Yes, I believe you were told yesterday there are some minor changes that we have made to our working copy based on a meeting that we had with Matt, Aaron, and Tiffany back in August. Those really aren't significant changes, but if you sense a divergence between what I'm saying and what you see up on the screen, it's because of those minor changes. One, for example, was changing, we had a word, I forget what it was, but we identified Aaron as office coordinator as opposed to some other word which really had no meaning within our organization. That's the type of change that we made, which is not in the red line you're looking at. So before you read the bylaws, I'm going to switch forward to the first substantive change, which is section 7. I'm sorry, I believe that's article 3. It's page 4 of my draft. And then down to 7 from there. So for this, our prior version identified working sessions. We're permitted to have working sessions. These are open meetings, subject to the Open Meetings Act. We did not have any particular formality to working sessions prior. So in consultation with Matt and others within the Road Commission, we added this language to set out an agenda, which, as I understand, this is what we already follow and would do so going forward. In addition, in this provision, we're just saying that these meetings will operate similar to regular meetings, except that the order of business is as put in there. It's not as extensive as a full meeting. Don't think there's anything there that is, yes.
Any questions, commissioners, so far? I have one. You've added approval of the agenda, and I don't believe we've ever done that in working session. I'm not objecting, I'm just trying to understand. And also the Pledge of Allegiance.
Well, I was just noticing that when I was looking at this. So we're not required to do that, and this is a draft, and therefore, if it is your custom not to do the Pledge of Allegiance at a working session, which has also been my experience serving on boards, we'll strike that part. As far as the agenda goes, it's sort of a Robert's Rules issue. I think it's good practice, but not, I guess, required.
Okay.
If the commission has a sense on this, we'll defer to that. But I would suggest that we actually do that because it gives individual commissioners an opportunity to seek to amend the agenda or to question it.
Okay.
Madam
Commissioner
Chair,
Green?
and I'm assuming that the working session is also separate to the Open Meetings Act, correct?
The what? Oh, yes, it is. Yeah, so we are having an open meeting at this point, and the public has a right to attend.
Go ahead.
What type of meetings are subject to the Open Meetings Act?
Well, it's
Anytime we get together or no?
pretty much yes. So any meeting in which there is a quorum and business is discussed, we deemed it open meeting. And this is actually a problem because you have councils or commissions say that they have lunch, right? Nice thing to do, team building. But you can run afoul of the Open Meetings Act if you have a lunch, private, you have a quorum present, and you talk about the business of the road commission. So any assembly which has the quorum necessary to transact business puts you at potential risk. And that's an example of what I would consider to be a trap. If you want to have a lunch for the purpose of team building and camaraderie, doesn't sound like a bad idea, but it actually can be. You have to be careful. And the answer to your question is even more subtle, because you can have a situation where you walk around and talk to other commissioners one-on-one. So you never have a quorum present, but you're polling them on a matter of business. And that can be deemed a violation of the Open Meetings Act. So when you get into these types of questions, you realize that things that appear commonsensical and are in no way done to, hide things from the public can in fact create issues. And some of the changes we're going to discuss, get into that realm, that you simply have to be careful that in any circumstance, when you're together with enough of you to make a decision and you talk about business, you could have an issue.
Commissioner McCollum and then Commissioner Yamas.
Yes, so by adding approval of agenda, that means that takes action for us to vote. And I didn't think we were supposed to vote during the working session.
Well, I mean, you can, but if you don't ever vote, I will leave it to you on that. The reason I said it would be good form is because it gives an opportunity for individuals on the board to identify whether you want to amend the agenda or what have you. I'm going to ask Stevens why I have him here. Any opinion on that issue?
Hello, Mr. Postma. How are you?
It's a pleasure to be here, and it's a pleasure to see another unit of government. I'm a municipal law junkie, so I read about the road commission. I ride on the roads.
Oh,
I'm interested in the roads, and so it's a pleasure to work with your body.
Thanks.
So the question is a good one. A lot of working sessions, the whole point of the working session is to provide for you to get information, but you're not going to necessarily vote on any of the items. That's done probably at your regular session. But because you've set up the working session like a regular meeting, it meets all of the requirements of the open meeting. You certainly can vote at that meeting. But I do understand that it's not a regular practice. So whether you approve the agenda or not, it's up to you. It is regular. It's a minor point, but it certainly can help. And going to Commissioner Green's point also, and Attorney Troika will talk about it. The meetings that why you can fall into trap also deal with emails and reply to all, and so we can get into that. But just because you're online and not and not formally here, a reply to all is something that you really need to think about. Some places all want to take the reply off the computer, so you can't even do it. But when you really think about it, if you're deliberating on a matter of public concern, wouldn't matter whether you're present all on a Zoom meeting or all on the computer. So you have to think about the content and what you're discussing.
Okay.
Yeah.
Question just in terms of your practice and working sessions. Is it informal such that if somebody wants to raise an issue, you're comfortable doing that without it being an agenda item or having that type of discussion?
Yes, I don't consider myself heavy-handed in that regard.
Yeah. So, I mean, on that point, as a formal matter, you don't have to approve an agenda. I leave that to you, but I'm happy to take it out of the draft if you believe that would be a change in your current practice and you don't want to change that practice.
What's your pleasure, Commissioner McCollum?
I think it's fine.
Leave it an item.
Approval of agenda, yes.
Understanding that would be the one time there
one
might be a
time
vote
might
by
need
this group. Otherwise, the whole point of the working session is to be liberated from those kinds of formalities.
I agree, and that makes sense.
Commissioner Yamas and then Commissioner Green again.
This is probably minor, but I've read the proposed changes in email, and the numbers were Roman numeral numbers and they've gone to numeric numbers. Not that particularly means anything, you know, does it just to,
And you're referring to the sub numbers under section 7?
no, like Article
Article 1,
instead of
yeah, I
Article
noticed that
1.
as well. We'll get that changed. We'll make it a Article 1, Roman numeral 1, Article 2, Roman numeral 2.
Yeah,
Okay.
so
Goes to Article 3, so we'll make those changes.
yeah, so instead of, they were the Roman numerals. was my
Agreed.
point.
I think that'd be,
Better, okay.
We will do that. That was certainly was not an intentional change. I suspect it's one of those software improvements where they made the change for you.
Yeah. So I have another question.
Is it about this section?
No, yeah, well, it's about what he spoke on.
Oh,
So-
okay.
So, I'm sorry, I forgot your name, but you.
Stephen
spoke on
Postema.
that- Oh, maybe you did, Mr. Rose, about polling, like if we talk to each other off, as long as it's not an intentional, hey, what did you think about X, Y, Z? I mean, it seems to me that has happened. I've held other political offices, and that was not uncommon to call and see how, you know, how people were, besides how people were feeling, how they felt about something that happened, not necessarily to garner support for any particular issue. So can you explain that?
So the important part of the Open Meetings Act is the concept of deliberation. There's two concepts in the Open Meeting Act. The easier one is a vote, because you're obviously not down the road at another place where the public isn't there making votes. The votes are done. The deliberation is the one that you would be concerned about, but the other part of that is it has to be with a quorum. So certainly you can judge whether you have a quorum and you're discussing something elsewhere that may be a problem. Your issue is a little more granular, and that is you may talk with an individual colleague about a matter that wouldn't necessarily be a violation of the Open Meetings Act because you're not in a quorum. And what Mr. Troika was referring to is there is a concept of a walking quorum, or a quorum where to get around the requirement, you have one person sort of discussing and relaying information from one person to another. This is it's a harder concept, but it really has to do with sort of defeating the idea of you know, you're in a quorum, you're not really in a quorum, but you're doing the same thing that a quorum would do. Now, just talking to one person, hey, how'd the meeting go? You're not in a quorum. You're not discussing policy. You're not doing that. Interestingly, there is a case out there that says just polling, that is, are you going to vote yes or no? A chair could do that before a meeting. It's a case called Ryan case. It's a tricky case, though, and I'm not sure it would be decided the same way by a court, because it's very hard. You have a disciplined chair here, I know, but it's very hard to poll, in a sense, each member without having some discussion back and forth. And that's why, while it's technically allowed under an older case, I think from 1992, there are dangers with that, because people will say, well, you know, that they went around the Open Meeting Act by extending it further than just a yes or no, and actually had the deliberation, the exchange, which is considered an exchange of information or a discussion. So I don't know if that helps you put it in context, but that's what they're concerned about.
Thank you.
Yeah.
All set? Mr. Green?
Yes. Given that working sessions are typically informal, and there might be a situation where these constructs, this order, might not want to be followed, are we then bound by this order?
No, for this you're not. The chair could depart from it in a working session,
Okay.
and that would be typical Robert's rules, the discretion of the chair on this.
Okay, we're getting into the weeds, Dan. I hope
Yes.
you're ready for that.
Well, so going to paragraph 9 in Article 3, there's a lot of red here, and that's because we just went through COVID and things changed and then they changed back. So the outcome of COVID was essentially there was a point where you were permitted to attend remotely. At some point, it was determined you can't do that anymore. Now we're back to a requirement of in-person meetings with certain exceptions. We revised this provision to try to accomplish two things. One is to capture the full rights that you might have under the Open Meetings Act to have a remote meeting or for individuals to attend remotely, and also to acknowledge what the current state of the law is, which is that the only recognized exception is if you're in the military. So the language we use is you can meet remotely for any purpose allowed under the Open Meetings Act, which at this moment would be just a military exception. But if the law is to change in the future, you wouldn't need to go back to your bylaws and change them. That new law in the future would be captured by the language we've put in here. So that was the reasoning behind why it's framed as any purpose, including the following, which is the military duty exception. There also are some requirements for when somebody participates remotely. These aren't particularly onerous requirements and are fairly commonsensical. One is there needs to be a way for two-way communication. I mean, entirely logical, otherwise you're not actually participating remotely. Secondly, you are required to put on the record that the commissioner attending remotely is in fact attending remotely, and that would be reflected in the minutes.
Comments, questions? I do. In this change, you have that people may vote if they're participating remotely. We have never, with the military exception, we've never accommodated that. We've made it clear that anyone is welcome to attend as a public member, but that commissioners can't vote remotely. And I also think in here that you've removed being able to see the person who's participating remotely. So my preference would be that we continue to follow the fact that you aren't allowed to vote if you're not physically present.
Okay, a couple of things on that. The military exceptions, as I think you were acknowledging, you would be able to vote in that case. Back in COVID, I recall, although maybe my memory is foggy, you were meeting remotely and voting remotely because by definition you weren't here. So as written, if we were to find ourselves in another COVID situation, you would be able to vote remotely. If we were to require in our own bylaws that the only voting permissible is in person, except for the military, and we were to be back again in a COVID situation, we would then be imposing upon ourselves greater requirements than the law would. You can state this in your bylaws. At the moment, there is no mechanism by which you can vote remotely unless you're in the military. So we're already in a situation where unless one of you is in active military, you have to be here to vote anyway. So the question we have is, do you want to lock in that you need to be here in person, except for any case involving the military, or do you want to leave that flexibility?
Do I remember correctly that there was action taken by the legislature to allow voting to occur remotely, but that sunsetted?
Yes.
We reached a point where it expired.
Correct.
And it was unique to the COVID situation.
I agree, yes. So if we were to have the bylaws amended to require being here in person and we had a repeat of COVID, there would be tension between a new legislative enactment that allows you to meet remotely versus a provision in our bylaws that says you have to vote in person. We can always put it in that way to say that you have to be here in person to vote unless the law allows otherwise, which is the case with active military. I just want to draw your attention that there could be circumstances that maybe we can't anticipate now where it would be reasonable to let somebody vote remotely. Do you have a sense on whether you'd like us at this point to revise it and include a provision that unless otherwise permitted by law, voting will be in person?
That would be my preference, but I understand we're not voting here today. We're just trying to give you.
No, understood. And, but
Take
we're
a
going to take,
temperature on.
we're going to take
preference.
your input and create a new revision. And so we certainly want to get as much feedback as we can get.
Commissioner Yamas, do you have a question?
I do. So I thought that we weren't allowed to vote remotely because it was against the Open Meetings Act, but that's not the case.
Well, no, that is correct. There was the brief moment in COVID where you didn't meet and vote remotely. And you can't vote remotely today unless you're in the active military. So the chair's comments is a correct statement. We cannot put into the bylaws a right to vote remotely outside of the active military because that would be contrary to the Open Meetings Act. The question is, do you want to bake into this the flexibility to vote remotely in the future if things change, which is what happened to COVID?
Or if there's a disaster. I think I kind of read about that right in here, like a natural disaster or something that.
I mean, natural disaster, I don't know the answer to this, but let's say somebody requests an accommodation due to disability. I haven't ever researched this issue, but there might be an obligation to accommodate. There are circumstances that could come up. Natural disaster, sure. If I can't imagine exactly what that would be here in Michigan, thankfully, but it could happen. Do you want that flexibility? We don't have to put it in there. We can keep it by saying you have to be here. But we are going to have to acknowledge that there are some existing statutory exceptions to that. Again, active military is the only one now. So to me, the question is, do you want to leave flexibility in there to anticipate future changes in the law, or do you prefer to simply state that it is our bylaws that unless you fit into an existing exemption today, you have to be here to vote?
Commissioner Green?
Does the Open Meeting Act provide for that type of flexibility or no?
No, not as things currently stand. As things currently stand, you have to be here. And I'm just going back to COVID. It was unanticipated. All the rules changed.
Right.
And when all the rules changed, we were meeting and voting remotely. If our bylaws had said you have to be here in person, then there would have been tension between what our bylaws said and what we were actually doing. Now, had we been challenged, I think we would have prevailed because we were acting in an emergency pursuant to a legislative provision that you can meet remotely during the pandemic. So in some ways, it's probably a scholastic point. It's unlikely we're going to have circumstances come up where you decide that now the law allows you to meet remotely, but you can't because your bylaws prohibit that. But that is the concern that was being addressed in here.
I have one more question in regards to the ADA Act. And I think like at one point I broke my femur and was gone for quite some time.
Wait, who was gone?
I was gone. When I broke my femur, I was out for some time. During that time, it's a disability, but there are no exceptions at this point in the Open Meetings Act for disabilities and being able to participate.
So not within the Open Meetings Act itself, but Stephen, do you know if under the ADA you would have the right to vote remotely or participate remotely?
We'd have to look at that further because the OMA is just not precise on that point. And so it would be an issue really whether that law would supersede this, but I'm not aware of any law in Michigan right now that addresses that.
Okay. So short answer is we don't know. If I had to bet, and I'm not a betting man, I think you'd probably be entitled to an accommodation in those circumstances because the ADA would be deemed to trump the OMA in those circumstances. But I don't know for sure. I'm going to imagine there's a case out there, but I haven't seen it.
Okay, thank you.
But that does go back to my point. If we state here, you have to be here in person, unless you're an active military, and then, heaven forbid, somebody breaks a femur, do we want to have the ability, if the OMA would permit it or the ADA would permit it, to have that person participate remotely?
Commissioner Green, did you have further?
No, I didn't.
Okay.
Okay.
My preference would be that you incorporate that phraseology that says unless otherwise provided by statute or law or whatever word you want to use. But I do believe we are obligated if the state legislature makes an exception. I don't think our bylaws supersede state law.
I do agree with that.
Okay,
I do. Mainly the issue was if the law changes,
sure.
do our bylaws automatically follow suit? But your suggestion is good, and we'll incorporate that in the next draft. You raised an additional point, which I don't know the answer to. Going to ask Stephen again. If someone participates remotely, can it be audio and not visual?
I don't know the answer.
Okay. As when we were preparing this, it was my understanding two-way communication was required, which would not include video, but we're simply going to have to check. If it is required to be video, we'll make that clear.
Because the phrase that was deleted in your amendment was the part that says can hear and see each other.
Yes. And it's my understanding that the requirement is that the communication go both way, which as written would not require video, but I don't want to sit here and state that I'm confident in that. So in our subsequent review after this meeting, we'll get a handle on that issue and make clear that it's required to be video if in fact that is the law. If we can move forward to paragraph 11. So the first part here is in keeping with the concept of flexibility and incorporating the law as it evolves, so that we are permitted under our bylaws to meet for whatever purpose the Open Meetings Act would allow. So there are certain exemptions that are identified today by statute. Those could change with time. And if they do change, we'll be able to do whatever the amended statute would allow. So that's the reason behind this change, just to make clear we're not limiting ourselves to this moment in time. We will capture any changes in the OMA going forward. The second addition there, where it says written legal advice, the way this is set up is it says you can do anything the OMA allows, including, and after the word including are some of the things that are currently allowed. We added the word written in front of legal advice because there's a very sort of tricky issue here under the Open Meetings Act. One of the exemptions under the Open Meetings Act says you can meet in closed session with your attorney to discuss litigation, but it has to be pending litigation, and there has to be determination that it would be in the interest of the board to meet in closed session versus public. So the question arises, and it's a very common question: what if you want to meet with your attorney for a threatened lawsuit or for some other legal matter in which the commission might have exposure, but there's not a pending lawsuit? Well, that takes you to a different exemption in the Open Meetings Act. There's an exemption that says that you can meet in closed session if there's a privilege under state law. And I'm going to pull the exact language.
Stephen has it.
To consider material exempt from discussion or disclosure by state or federal statute. So what the courts have said is that in circumstances where a board wants to meet with counsel for an attorney-client privileged discussion, and there's not a pending lawsuit, they will look to state or federal statute to see what types of materials are protected from disclosure. The reasoning is kind of odd, and I would say unexpected, but the current state of the law is that if you have a document protected by the Freedom of Information Act from disclosure, you can then meet in closed session to discuss that document. So what that requires your attorney to do is to put legal advice into writing, which then it becomes a record, and it becomes a record that is not subject to disclosure under the Freedom of Information Act. And then you can invoke this exemption under the Open Meetings Act. It's not intuitive. I would think, and in fact, I'm inclined to believe you should be able to meet in closed session with your attorney without getting in advance written legal advice. But the current state of the law is you need to get that written legal advice first if you want to go into closed session and meet with your attorney to discuss legal issues that do not include pending litigation. So we put the word written in there to acknowledge that's what the current state of the law is. If the law were to change, we still have a broad statement that you can meet in closed session for any purpose permitted, but we felt that it was wise to acknowledge that limitation. Otherwise, it's easy to overlook it.
Commissioner Green.
And so if the attorney were to write on his or her letterhead that he or she needs to meet with the board on an urgent matter, not disclosing any details what that matter might be, that would satisfy it?
Probably not. You probably need the attorney to actually state enough so that it becomes advice. Because a simple letter from an attorney saying, I want to meet, we want to discuss something without identifying what the advice is going to be and what the issue is would not be itself protected by attorney-client privilege. Stephen, did you want to comment?
Yeah, so there's a lot of case law at this, and what you all as commissioners hate to hear is this is sort of a gray area in the law. I know every one of you doesn't want to hear that, but the case law develops, and they've really talked about having a written legal opinion, actually. You know, so it's not just we want to talk to you about something. It's about legal advice that you're giving on a properly legal matter. So it's not something that is outside of our expertise. It's not a policy issue. You don't ask us for, what should you do on some policy matter. What you want to know from us is what does the law say about something that we're going to do, or what is the legal implication of this? And so usually we put that in a written legal opinion to you. The case law deal talks about that, uses those terms, and it's another way to show that when you go into closed session, you're focusing on one thing, that is the issue before you, so that you don't stray from other things. And again, the Open Meeting Act doesn't assume that you all want to do things that are improper or outside the scope. You want to comply with the law, but the Open Meeting Act is tricky. And so this is another way that the law says, if you go into closed session on a written legal opinion, that the commissioners and the public know that you're going in for a lawful purpose, and it actually protects you then. We were just reading a case that came out 2 years ago. And interestingly, the plaintiff is called Mr. Sunshine. And so it goes into great detail about these very issues, about complying with every requirement about going in. And but on this point, which is an excellent point, it's not enough to just say, let's go in under a written legal opinion and not have anything there. The law doesn't want us to do that. The public doesn't expect it. And so usually, now it is true that you could do it in advance, and I've done it before where an issue came up right in the meeting, and I was asked to prepare something in writing, and while the meeting was going on, prepared it, delivered it, and to satisfy this very requirement. So an excellent question.
I also want to add and just make clear that there are several exemptions. So if you're able to go into closed session under a different exemption, you wouldn't have these procedural hurdles. So for example, I come before you for condemnation matters, that would be pending litigation, and in addition, a real property acquisition, both of which are exemptions. So we don't have to worry about the written legal advice issue in those circumstances. Same with collective bargaining, certain personnel matters subject to certain requirements. You can go into closed session. You don't have the same concern. But there's a big picture concern here because it's counterintuitive. It seems to me obvious that a public board should be able to meet in closed session with its attorney to get legal advice, but it is not that simple. The provision of the OMA that deals with actual litigation requires it to be pending litigation, and also requires that it be a benefit to go into closed session. So if it's not pending litigation, it has to be written legal advice, not we're going to talk about this subject. So that's something that personally, if I were writing the law, I wouldn't require that. I think you should be able to meet with your attorney to discuss a topic and not have the rigmarole of having a written opinion in advance. But you do. You have to have something in writing in advance if you want to stay within the four corners of the Open Meetings Act as currently interpreted by the Michigan courts. I will add, it's entirely possible at some point the appellate courts are going to look at this and say, you don't have to go through written legal advice, and that itself comes from the Freedom of Information Act. Outside of the Freedom of Information Act, there's already a recognized state common law privilege. to meet in private with your attorney, but no court has yet said that that by itself is sufficient. So that's why we're advising using the word written, and in fact, having your practice be that there be something in writing before you go into closed session.
Just two nuances here. Your provision in what's written before us does not specify pending litigation. Does it need to specify pending litigation?
I'm going back to
Third line from the bottom, last word on that, section 11.
So, I mean, short answer is it wouldn't hurt because it is correct that it has to be pending.
It does have to be pending.
Well,
okay.
It does have to be pending if you're going under that exemption. If
okay.
you're going under the other exemption about material exempt from discussion or disclosure, then it does not have to be pending litigation. But putting the word pending in front of litigation would more closely track what the OMA actually says with regard to that particular exemption.
Okay.
So I don't see any harm in doing that.
Well, I'd rather not be further constrained if it's not necessary, but you had mentioned pending and I wanted to be clear on whether that was your interpretation
Yeah,
or if that was a word we needed to.
It is probably better to add it because conceptually what we are doing here are identifying the most common exemptions under the Open Meetings Act, and what's known as the litigation exemption does require that it be pending. Again, you go to the next phrase, written legal advice, that permits you to meet about threatened litigation that's not pending.
Okay. And then also in terms of what can be discussed in a closed session, I think that's pretty clearly specified that we have to state why we're going in.
You do, yes.
Okay. Any motion that I've asked for in the past actually states to talk about why Barb has gray hair specifically. Right. I mean, there's a specificity about why we're doing that. Not
There's a
because
requirement.
we feel like it.
And you also have to poll the commission before you go into closed session.
Right.
Now that is in the statute. And when I've come before you to go into closed session, I indicated in our memo and in person that we have to do it. We can actually add that into our bylaws if you believe it will be helpful. To some extent, you might be relying on your bylaws rather than going and reading the statute itself. So it might be helpful for us to specify that in this provision of the bylaws so that if you're reading it, you understand that there are certain procedural requirements before you go into closed session. So that's something I at least will think about, and I think it's a good idea, and we probably should specify that in the bylaws.
You usually quote an MCL, right?
We do, yes. Yeah, when we come here, we do. And I think the question is, maybe we put it in the bylaws. It's already an existing requirement because it's a statute, but it will be helpful if it's in the bylaws because if somebody's relying on the bylaws for practice, if it's not in there, they may overlook that requirement. So that is definitely a good suggestion.
Chair, was your question also the level of specificity? For example, I'm not sure what your current practice is, but if it is an existing piece of litigation, you would cite the OMA rule for going into closed session and litigation, and usually you would put the case of John Doe versus the commission, and that is the best practice, and that can be done. Interestingly, if it's on written legal advice, there's a case that just came down, the Mr. Sunshine case, that said you don't have to do more than state the rule that you've gone in on counsel opinion, but you don't have to go into counsel's opinion that this is, you don't have to have the same degree of specificity as you do for a piece of litigation. And so that's just a minor point, that citing the rule itself was acceptable, but it certainly is a best practice to cite the specific piece of litigation. And
typically, Dan, don't you write that for us?
We do, we do.
So we're in the clear with respect.
When it's in condemnation, we always spell out that in detail. We think that that's good practice.
Dan, I'm sorry, Matt, did you have a question?
No, I was just going to say that to add pending litigation and the word litigation, because they're different, I would think.
And what litigation?
Just
pending
litigation, meaning it doesn't have a case number. and then litigation, which actually does have a case number.
Got
No, say pending litigation does mean it has a case number.
Okay,
Yeah.
very
So,
good.
yeah, that's a filed lawsuit.
Thank you.
All right, let's move forward to paragraph 12. So not much here I'm trying to remember if county commission reports were in there before and we moved it up, or if we just didn't have a space for it. But I believe our discussion was that we would want the county commission reports to be earlier. I think that is our current practice.
Correct.
Okay, so in this case, we're just acknowledging what we currently do. It's my understanding we don't want to hold them to the end of the meeting.
Correct.
So they have flexibility.
As a courtesy to them, yes.
And that makes sense. So this is just acknowledging that's where they would go in the order of business. Let's look at 14, paragraph 14, and at the very bottom. So this gets into thorny issues of the OMA, as if we haven't already had enough. And the question of what can you do to control public comment if it gets out of hand? That doesn't happen often with us. I don't know that we've ever had public comment really get to the point where you can't manage a meeting. But if you're in a circumstance, for example, where you have 50 or 100 people show up and they're all saying the same thing, what can the chair do? What can the board do? The law here is less than clear, but one thing that is fairly clear is you're not permitted to curtail people's right to speak based on the content. So in the bylaws that currently exist, it suggests that if the board or if the chair believes that the public comment is cumulative, let's say you have 50 people reading a script, you can't say, well, we're not going to hear the same thing over and over again. That would be content discrimination. So you're simply not permitted. Now you can suggest that if there's a group, somebody be appointed to deliver that message as opposed to being repetitive. But you would be towing the line, probably violating the OMA to simply say, Jane, you're just repeating John, sit down. And even though that is a sensible thing to do in many circumstances, and if you weren't governed by the OMA, if it were a private board, that would be entirely permissible under Robert's rules, you can't do it here. So in dealing with this, first thing, and this is a change that you should think about, with regard to establishing time limits, there's an ongoing question about how much time is adequate for public comment. 3 minutes? Could you do 30 seconds? If you have 100 people here, could you reduce it? We haven't said, and we don't know what the outer limits are on these principles. Maybe a minute would be defensible if it's a highly attended meeting, maybe not, and maybe the sort of thing that will only be found out ultimately in court. But with regard to setting time limits, we made it a board function as opposed to a chair function. The thinking being that this really gets into potential OMA violation territory, and it probably ought to be done via board decision. It can be done by the chair. We can keep it the way it is. We think it would be safer that if you're actually going to alter your designated 3-minute slots, that the board itself make that vote.
Commissioner McCollum, Commissioner Green.
So the board, so what would the chair give a suggestion of how many minutes, and the board motions to approve it, or?
I would say so. Stephen?
If you're talking about a waiver period, if you usually have a set time period, are you asking about a waiver of that period, or?
Well, it says here, it's crossed out that the chair not do the right to establish the time. It's the board that's going to be in agreement of that. So would that be a motion to a suggestion of a time? And then, in other words,
if we want to go from 3 minutes to 2 minutes, the proposal of the board make that decision.
Right. And then if the chair wants to say, we're only going to hear comments for 20 minutes today from the public, as opposed to limiting the individual, right? That's the distinction between the two pieces here.
Right. Now, you get to a good point, Chair, about limiting the time period. Right now, the OMA and the case law doesn't really say that you can limit the time period for public comment in total. In other words, so that you would exclude, let's say you you did it 21 minutes, so you only 7 people could speak for the 3-minute. The OMA doesn't really seem to allow you to do that. And you may be thinking, well, what happens if 100 people come and there's 3 minutes each, and that's 300 minutes, and that's 5 hours. I've been to 5 hours of public comment, and the law doesn't deal with, let's say it's 1,000 people. The law does not, the outer limits of that have not been tested. Now, we can suggest ways that you can manage this. There's ways to do that. But I read occasionally, and like I said, I'm a municipal law geek. I read that somebody said, well, it's a blanket 30 minutes, and after 30 minutes, everybody else just doesn't get to speak. That is not what the law says right now. And so we have some suggestions for that too.
Right. So in the actual proposed revision, you would be able to set a limit on the length of public comment at that point in the order of business, and then defer any further comment to the end. So that is one way of permitting. Okay. And then this gets to the question that Stephen was alluding to. Let's say this does happen and you get to the end and you still have 100 people. Are you required to stay here till the sun comes up? No, you're not. And you probably have to tolerate more than you would want to if it really is an organized effort to filibuster. But at some point you can adjourn the meeting and have people come back if they still want to make comment at a future date. Would be risky, although I think defensible at some point, just to say, we're done, we're public servants, but we're not required to stay here past midnight. But the law is untested on if there really is a point in which you can tell a member of the public that you have lost your opportunity to speak because other people got there first. That is untested. If you're ever in that situation, you want to err on the side of caution. At the end of the day, it's unfair to ask you to be here, through the night. And at a minimum, you can adjourn it and allow public comment to resume in the future.
Commissioner Green.
Yes, so if you go back to the previous paragraph.
14B.
Tiffany, yes, 14B. Where it says the chair of the board retains the right to establish time limits. Does that now mean that if there's a question or determination as to what the time limit should be, that there has to be a vote now?
So if it's a global time limit, that will be a chair function. So the example there would be your agenda provides 3 minutes for public comment. Turned out it's a hot button topic and there are 100 people here who want to comment each 3 minutes. The chair could say, we are not going to have 300 minutes of comment at that section in our agenda. We will limit it to 30 minutes and we'll defer to the end of the meeting any further public comment. So that would be how to deal with the immediate issue of being unable to conduct your business because of a lengthy public comment period. When you then get to the end of the meeting and you resume public comment is when you may have the issue of, the clock strikes 12, should you really still be here? There's no clear answer to that, which is why I would say err on the side of caution, but certainly there comes a point where you can say and should say, we're adjourning. And if somebody has comment, they can come back. I personally will be okay saying you can come back to the next meeting as opposed to having a special meeting just to resume comment. But the law is very untested there. The courts are sensitive to people not having the right to speak, all of which we agree with, except when there's so many, you can't conduct your business, which you as public officials are required to do. So there's a balancing that has to take place here, and the courts have not determined the outer limits of what you can do to regulate your own meetings in the face of a very spirited public comment. Again, I don't think this has ever actually happened to this board, and we hope that it does not. We want to be accommodated.
It did once in my memory.
Was that the trees on Mass Road? Or
Yeah,
okay.
yeah.
I've heard stories.
Yeah.
My only suggestion on that is what you all would think of as common sense and what you as a chair would want to do to run the meeting properly. A judge at a later time might just take a different view of it, and without castigating the judiciary, they may have a very sort of ivory tower view of it rather than the practical necessity of helping governing. So.
Sure. Commissioner Green?
Yes, so the question I have, the way it's written now, the chair has the authority and the right to establish the time limits.
No, not with,
I mean,
oh,
well,
the existing bylaws
well,
without
yes.
the red line?
Yes.
Okay.
Yes, that is correct, under the existing bylaws.
What is the value in taking that authority away from the chair? I'm just trying to understand that. Because that seems like something that she would need in the event that she needs to just.
So the short answer to that, this is the
Maintain
judgment
control.
call. And I would say it would be perfectly fine and appropriate to retain that as a function of the chair. The reasoning is the circumstances in which reducing public comment from 3 minutes to a lesser period of time are typically going to be, pretty hot issues with a lot of people here. That's why you would do it. And you're not allowed to say, well, we're not going to let these people speak because they're being repetitive. And currently we actually have that language in our bylaws, but you really can't do that without running into some potential issues with Michigan courts. So it was our judgment at the time of doing the revision that it made sense to require the board to deal with how individual presenters are constrained as opposed to the chair. Not a requirement under the Open Meetings Act. We could keep that with the chair. It's highly unlikely you'd have a situation where the chair and the full commission disagree on this, but the intent was to require that minimal moving and deliberation if you're going to tell somebody that your public comment is being curtailed from what we normally afford.
Does that answer your question,
Yes.
Mr. Green?
Yes.
It doesn't answer the question whether we should do it or not. I mean, it's a very good question. And I'm happy for it to be a chair function. It's certainly.
I'm sure you are.
It is a customary type of chair function, and we're sort of dealing with the sensitivities. Like the Mr. Sunshine case, this is a person who sues, based on, sunshine is the best disinfectant. We get it, but those people then start to really nitpick. So if the chair has said, we got too many people here, you got a minute, you don't have 3 minutes, there at least is some exposure to being told that wasn't sufficient.
Commissioner Yamas?
So to the change, I don't think I have an opinion one way or another, but the way it's written, does that then mean that the board needs a motion to decide as a practice, we're going to use 3 minutes, and then the chair has the opportunity to change that as it appeared, case by case basis?
So at least my intent, and there can always be a disconnect between what I meant and what the words say, but the intent is you have a norm, which is 3 minutes. You don't need to have a motion and a vote to do your 3 minute public comment. It's when you are departing from that, which you would really only do in a crowded meeting. And in that context, we are recommending that the board actually make the decision to curtail individual presentations from 3 minutes to a lesser time. But it can still remain a chair function.
Would that require, I guess my question is technically, would that require a vote?
Yes.
That a motion?
Yes.
Okay.
To depart from the 3 minutes, which is otherwise what you allow. So
that's
yes,
what I was wondering.
as written, it would require a motion and a vote. Again, perfectly fine to make it a chair function. If you know that you want that, then we would go ahead and take that revision out. Or if you want to think about it, you're going to get another version of this to look at.
Well, this would more protect the chair, right? Because it's just a broader thing, and it puts.
Yes.
Okay.
Yes. I mean, while we're not really, I know we're talking a lot about the Open Meetings Act. We'll really hear about your bylaws, but I will say that when you read the Open Meetings Act as a public official, pretty frightening. I mean, there are criminal penalties for intentional violation. And what's an intentional violation? I mean, it's, if you don't understand what the act says, it's hard to intentionally violate it, but there is risk of, prosecution or even personal liability for an intentional violation. So yes, it does protect the chair. There is some irreducible risk to serving on a public body and being a chair. So that's just the nature of what you do and what all of us do who sit on public bodies. But this would be protected by the chair.
Okay, thank you.
Commissioner Green?
Just to say, from the standpoint that it protects the chair, I get that. But I would just hate to see a situation where that type of authority is taken away from the chair when she may need to exercise it. That's all.
So it's true. It would be taking it away from her if you want to reduce the 3-minute public comment to say 2 minutes or a minute and a half, yes, and it would. So that would require a motion and a vote in order to change. And the thinking is this is a sensitive topic, one that really isn't settled by the courts, and therefore it will be more protective and procedurally defensible to be a vote. I wouldn't say it's a big issue, but that remains our recommendation.
Mr. McNeil.
I would just point out that even with the current language as drafted, the chair could still say, this is going too long. We're going to close it at 30 minutes and you can do it at the end of the meeting.
Yes.
So the chair still has the power to limit at some level and to conduct the business of the board. So the chair,
It does.
that's what
down here.
the second sentence says.
Yeah. You need to.
So the chair still has the ability to say, we've got to conduct our business here.
Right. So the reasoning there is that
I
it's
see that.
historically a sort of a Robert's Rules function of the chair to control the meeting. You know, what exactly does that mean? That we can't say in all cases that we're confident that one circumstance in which the board can control the chair is to limit time on specific agenda items so you can get to the next agenda item.
Final
Mr. Green?
question. Yes, that's it.
Wait, okay, I'm writing that down.
For right now. I'm assuming there's a situation where the chair of the board could say maybe 30 seconds per person, and that itself might be a violation because the person said, well, that's not enough time for me to
Even say Monday.
make my expressions known.
So, and I don't believe there's any case law that establishes the lower limit. And I have heard 30 seconds proposed for an open meetings limitation. My opinion is it's probably just not enough. There's not much you can say in 30 seconds.
Right.
I agree. Less than 30 seconds, yeah.
An attorney being brief.
3 minutes, you know, the public sometimes bristles at 3 minutes and, but 3 minutes is quite a long time. 5 minutes is very long, but there are places that have 2 minutes and they do just fine with 2 minutes. So 3 minutes is not a stingy amount to give to the public, and it's more than reasonable.
Is there a minimum?
Pardon?
Is there a minimum required that we must give a participant?
The law is not clear on that, and it would have to come. Certainly, you know, you'd lose if it were 5 seconds. I can tell you that you'd lose on that. You'd probably lose on 10. Going up, you could probably win at 1 minute, but between there, it's the gray area that you don't like to hear about, and you wouldn't necessarily want to test it. And so, at least in Michigan, we haven't done an omnibus search of how this is in any other state, but in some ways we don't care because it's not the Michigan OMA. But it's a great question, and you just like to know. You like to know the parameters, and we don't want you to be on the edge. I've been on the cutting edge of a lot of things. I don't like to be on the cutting edge. I like to be away from the edge. And so that's what we're trying to do for you, okay?
Commissioner McCollum, did you have a question?
Yeah, I was wondering, I'm not sure if this applies to Michigan Open Meetings Act, but I've seen it in like the other governing places where someone will yield their 3 minutes.
Yeah.
And give it to the person still talking. I mean, is that?
You know, that's a good question. I've got to think you can't artificially pump up your time to say 30 minutes by bringing 9 of your friends, but
Yeah.
I've seen it, but that's more usually in the legislative context where people yield time. I don't believe the Open Meeting Act would require you to honor someone to bring you know, all of the relatives. Now, all of the relatives could all read from
Right.
script. That's a different thing.
Right.
But now the interesting thing about, you know, Robert's rules is oftentimes if somebody doesn't have a right to speak and it's not in the municipal context, oftentimes people say, okay, we'll give the leader of the group, you know, 10 minutes and everybody does sort of agree not to speak. And so that is it makes perfect sense. It's just not, that's not what the Open Meeting Act. The Open Meeting Act isn't there to make sense. It's there to give rights to people to express their views to government. And that is a different concept than the efficient running of a meeting in let's say, the private sector.
Thank you.
Yeah.
One last question, Dan, where's our 3 minutes? Is 3 minutes in the bylaws?
I don't believe so. I think you just stick it,
It's
do you
just a-
put in the agenda 3 minutes? I think
Yes.
it typically says that. So no, it's not in there. I
Okay.
mean, we could make it default, but it's really, I would say it's an established practice. So you're not going to need a vote on 3 minutes. You would need to vote if you're going to change it.
Thank you.
And yeah, I'm curious on a point you're asking. I don't know if Stephen's dealt with this. I think if you had 10 people and they said, we want this person to have 10 minutes and you agreed and nobody was objecting, I don't see how that could later be litigated if it were consensual. Not saying you should do that. We don't think you're required to give anybody more than 3 minutes or whatever your allotted time is. But if it served a purpose and there's no objection, and what's your thoughts on that? Or is that?
The interesting thing about a lot of these rules that seem to constrain people is that once you start deviating, then where the law comes back to bite you in some ways is that, well, they gave 10 minutes for this position to be explained, and yet the chair didn't give, stuck with the 3 minutes for this position. And again, it comes back to when we talk about protecting the chair, it's you have that discretion, but somebody will say they're biased against this person and therefore it's viewpoint discrimination. That was not the intent to do it. It was to be economical or some other reason, but being the chair it puts you in a difficult position. And once you exercise discretion, people can say, well, that discretion is you had this intent or that intent. And so, yeah, you can waive rules, you can do all sorts of things, but when you then don't do it, they'll bring an example and say, see, in this position, we're being discriminated against. And so that's really the caution on both having rules and waiving them.
I appreciate that. There's some risk if you do it. It gets back to the division between common sense and what the law might require. I know we're a little bit past our time. The last two changes aren't particularly substantive, but I will, I guess 3 changes. We'll mention them. For staff presentations, under the current version of the bylaws, it says they're governed by the regular order of business requirements, which technically would limit staff to 3 minutes. So we simply removed the regulation regarding staff presentation entirely and leave it at the discretion of the chair. In practice, they're going to present more than 3 minutes in many cases, so we don't want to inadvertently have a time limit on them. Instead, it will be at the pleasure of the chair. On disorderly conduct, we just added the tautology that you can only remove somebody if they are disrupting in a manner not permitted by law. Only reason for that is you can't do it just because you don't, like them or that disagree with whatever like political position they're espousing. Is that self-defining? It's not, but somebody has to be disrupting a meeting in such a way that you can't conduct your business. And in those circumstances, you can call the police and have them removed. But it can be simply because you don't like the content of their words.
Commissioner Green?
Yes. The question as to whether somebody is in order.
What are you looking
I'm
at?
sorry. Paragraph 20.
Yes.
Of disorderly conduct. It says such person shall therefore be seated until the chair shall have determined whether the person is in order. That sounds very subjective.
It is subjective. And for that reason, a chair should not exercise that function unless somebody is disrupting a meeting in such a way that you can't conduct business. That can be with the volume, be talking over people, being unwilling to let the meeting flow. Things like cursing get really, you get into gray areas. There's some level of profanity where I believe a chair could call somebody out of order. It is subjective. And for that reason, you should only do it when, in fact, the person is making it impossible or nearly impossible to conduct business because they're not following the rules, not letting other people speak. And hopefully that doesn't happen, but you do have to have that power. You ultimately have to have the power to call the police and get somebody removed. In a rare circumstance, you can see this on YouTube, somebody showed up and threatened to kill. It was like a school board or something. And yeah, the police there was actually a police presence in that case because it was known to be a controversial meeting and they were arrested for that reason. So clearly that type of situation would meet the standard. If somebody just gets up and gives an impassioned 3 minutes and you think they're nuts, that's not sufficient if they sit back down when they're done. If they won't sit back down, if they won't let other people communicate, you have the right, that's really an inherent right of a chair under parliamentary procedure to take action. In practice, you'd have to call, the county sheriff to come and get the person removed. Or you do have a law enforcement officer on staff, so maybe an option.
And procedurally, Chair, I don't know if your current practice, whether you have a little script about how to call someone for being out of order. We can supply something like that to you that gives you something that you can put on the record to give someone notice before law enforcement presence would enforce that. So if that would be helpful to you, we can certainly prepare that. Unfortunately, we in my prior occupation, we had to use that. So I got to refine it over time.
Dan, is open carry allowed during our meetings?
I'm going to ask this gentleman. That's been litigated. I had to deal with that a bit with the
last time I looked that there was no prohibition against that. There's a case, but we'll check that again. And interestingly, public buildings and public meetings were not covered. Again, we're not talking about common sense versus the law here. But the last time I looked, which was a while ago, it was allowed. I have my own opinions on that, but in any case, there are other things that you can do if that occurs. So
okay.
So we'll look and see if we can get the current answer. I know where it came up with the Ann Arbor School District. It was found that open carry was not permitted, that the superintendent statutorily had rights to govern the academic experience, which would allow them to prohibit open carry. But the law allowing open carry is surprisingly broad, and it may be the case that you can't address it. That being said, we'll take a look at that.
Thank you. Commissioner Green?
If there is a situation where someone comes in, maybe a group, brandishing weapons in an attempt to intimidate the board, does the board or the chair have authority to shut the meeting down?
Oh, sure. If somebody brandishing a weapon in a threatening manner is the crime of assault, and your paramount duty is safety. If somebody is behaving in a way which implies potential violence, yes, and you do what you have to do in those circumstances. You're not required to take a bullet under the Open Meetings Act. The open carry issue, if you're open carrying, but you're not brandishing, you're arguably within your rights. I don't like it because a person with a gun who gets in front of you and argues against you, it's inherently menacing, especially to a public official. But the law has been trending in the favor of open carry in recent years. Last bit was just we put in a provision regarding minutes for closed sessions, and that's just tracking the Open Meetings Act.
Right.
So we are on our end going to go back, make some changes based on this conversation, which has been very helpful. You've asked a lot of questions, some of which we had, some answers on, some of which we don't know. Maybe there's an answer and we don't know it. Maybe that there's actually not an answer because the courts haven't resolved. But we're going to go back and take a look at those questions and produce a new proposed revision and get that back to you via Matt, Aaron, and Tiffany in the short term.
Thank you, Dan.
Thank you. Thank you.
Right.
Thank you.
Thank you, everybody. It was a pleasure
Thank
meeting
you,
with
Stephen.
you.
Pleasure to be here. It's nice to be at a 9 a.m. meeting. It's a lot of common sense here at 9 a.m.
Our best.
Thank you.
Okay. At this point in time, we're due for a little break. If we could please go ahead and take a break, but be back here and ready to go again promptly at 10:30. We are in recess. Welcome back. We are reconvening our working session, and I will once again turn this over to our Managing Director, Mr. Washtenaw.
Thank you, Chair. Our next agenda topic is Gallup, and I have here Nicole Peterson, our HR manager, that is going to walk us through a presentation on understanding the 12 questions and some of the survey results. We had a Gallup survey back in April. So with that, go ahead, Nicole.
Thank you, Nicole Peterson, HR manager. So we'll dive into the 12 questions for Gallup. I know we've touched on this topic a little bit before, but I'll do a brief overview and then get into our results. So really, Gallup was created in the 90s at this point. So we have about 30 years worth of data that the organization uses. They've since interviewed or surveyed about 12 million plus employees at different organizations. So when we're reading numbers, our mean compared to that database will help you understand some of the percentages that we have, even with the handout that was given to you. So those 12 questions, this was our second year in a row, performing this in April. Really just trying to measure employee engagement within our organization. There's a hierarchy of needs when it comes to those questions, and we'll break that down. So we start with those basic needs, getting into relationships, and then the growth and development of an employee. So that first section of those needs is our first three questions. Like I had more on that slide, but this first section of the three, and then I break down what the significance is of each question. And I'll have you focus on number 2 was a lower one for us. So if we see I have the materials and equipment, I need to do my work right. The significance being the availability of resources and tools. So we'll look at that again. We then have the next section of the hierarchy of needs, questions 4 through 6. Do you want me to read through them, or you're able to see them in the presentation and the handouts?
It'd be helpful
to read through them?
Sure.
Okay.
Just for people who aren't here.
Okay.
Right, or may not have a screen in front of them, Nicole.
Okay, I'll go back. So question 1, I know what is expected of me at work. The significance being the clarity of role and responsibilities. Question 2, I have the materials and equipment I need to do my work right. Availability of resources and tools. Question 3, at work, I have the opportunity to do what I do best every day, which is utilizing skills and strengths. In the last 7 days, I have received recognition or praise for doing good work, your recognition and feedback. My supervisor or someone at work seems to care about me as a person, employer-supervisor relationship. There is someone at work who encourages my development, and that would be support for growth and development. At work, my opinions seem to count. That would be the employee involvement and influence. The mission or purpose of my company makes me feel my job is important, your connection to organizational goals. My coworkers are committed to doing quality work, teamwork, and commitment. And that final tier, I have a best friend at work, which is your social support and camaraderie at work. In the last 6 months, someone at work has talked to me about my progress. That's your career development discussions. So that was another one I'll highlight as a low. And then this year, I have had opportunities to learn and grow. That's your opportunities for personal and professional development. The benefits of having a high employee engagement. So we've talked about, there's cost savings, productivity, just having that employment engagement helps with turnover. It makes a stronger company culture. It helps with that recruitment and retention. When we do the Q12 questions, we first administer the survey. We analyze those results that comes from Gallup and then share the results with us. We, as the employer, identify the areas for improvement. Each supervisor is tasked with developing action plans, which is easily done through the Gallup website, and all supervisors have logins for that. And they do a lot of step-by-step in the program for them to be able to do the action plan and implement with their team. And then we continue to monitor progress. So for example, at every supervisor's meeting, we try to touch on the Gallup survey or a specific Q12 question. And I'll actually be going over this presentation with the supervisors at the next supervisors meeting this Thursday. So how did we do? That's not my, I knew there were things missing. That's not my part. There's something not right.
One of the things we'll mention while they're straightening out the PowerPoint, when staff is asked to answer these questions, it's on strongly agree meaning 5, and then strongly disagree meaning 1. So it's basically, you're going to see the results with numbers, and so you're going to have a range anywhere between 1 and 5.
Yeah. So actually, and I had a slide on that, so I'm not sure.
Number 4.
Okay, thank you. Yeah, that's true. You've seen more than I maybe see. You can go to the one we were just on. Thank you for your help. So how we did this year, we did have a slight change from last year on our overall engagement for the entire organization. And really, I'm just looking at the big picture today with you. So we, our mean was a 3.73. We had a total of 102 respondents.
Out of how many possible?
Oh, at the time, it was probably 116 would be my guess.
Okay.
We typically have about
Also up from the last time we did this. So this is the second time we've done the Gallup survey. We've done them both in April. So it was good to see we crested over 100 because I believe it was in the 90s last time. Yep. So right. and normally we have 130 full-time employee positions.
Right.
But we have a variety of vacancies. So
136, and then we typically have, with drivers anywhere and a couple engineering, 8 to 10 vacancies. So, but yes, we did improve on the number of respondents, and then a slight change from last year's overall. And I think if we reflect back on all of the changes that we've had, just even in the organization in the last year, and not that they were negative changes, but change is hard no matter, right? With Cheryl's retirement and Matt's new position, and then that trickle down effect that went throughout the organization. Because this is really just a snapshot in time, right? It's how that person was feeling that day, maybe that week, and that's what we're able to capture. And it could have improved or it could have gotten worse since then. We don't know. Next
Commissioner
slide.
Green. I'm sorry, Commissioner
Yes,
Green.
please.
Yes, out of 116.
I'm thinking it was about 116. We only had 102 people respond. So it is voluntary. It is not required,
Right.
but it's highly encouraged. And we make it as easy as we can. There is an email that goes out. We have QR codes so they're able to scan it. We've had people go around and meet with employees, supervisors, assist, maybe need to set them up and walk away. We try to help as best we can, but it is not a requirement.
And it's an anonymous survey. That's the beauty of working with Gallup, that we don't see the results of any one individual. In fact, if the group is smaller than 4, then we can't see that individual group's results. It gets rolled up into the department.
Does that answer your question?
Yes, that's a very good response, I would think. 102 out of 116.
Right.
That's excellent.
Yeah.
Very pleased.
We, what we've talked about right from the beginning when we started this last year was this is your opportunity for your voice to be heard. I know it's just a survey, but there's a lot of follow-up conversation from foreman or supervisor to their group, and then whether Matt has gone around or Cheryl to the different groups, and just opening up those discussions. So this is what we try to promote as, you know, this is your opportunity. How are you feeling? What's working? What's not? What would you like to see changed? What would you like to be better? What keeps you here and what would make you leave? So those are the types of conversations we're trying to have.
Gloria, did you have a question? I thought I
No.
saw your hand. Okay, okay.
Nicole?
Yeah. Same 12 questions as last time? I mean.
Yes, they never
okay.
change. Correct.
Okay.
Yes, they've been the same 12 questions. So here we have one of our high scores. And so this was the question. Is this one of our high scores?
This is the overall.
Oh, the overall?
Yep.
Okay. Then I need the next slide. That's right.
Oh, Commissioner
Can
McCollum.
can we go back to the last slide for a second? Because current top box. So the scale you have here and the engagement, not engaged, equity, disengaged. That's what this scale is? Or
Yes.
no?
That would be how you got the mean for the 3.68.
Yeah, this is a summary of the overall engagement based on the 12 questions. This isn't the answer to a specific one of the questions. This is Gallup's engagement based on your 12 question results.
Oh, I see. Okay, because it was like, it seems like we have a high response, so that those numbers didn't quite, 102 out of 116 doesn't mean 36 people are, 36% is engaged. I mean, that seemed off to me.
It's higher.
Or the engagement index seems like it should have been higher.
It's 3.68 out of 5.
Oh, I see.
So again, the questions are 1 through 5.
Okay.
And so that we scored a 3.68 on total engagement of the workforce of the respondents. And this is a combination of the 12 questions, essentially.
Okay.
So it's kind of like your grade at the end of the paper, not all the questions individually graded, but overall, this is how you scored as an organization.
Okay. So
and then they're comparing it to the overall Gallup group, which is enormous. So for a government organization, you're getting compared to their entire list of employers.
Okay.
Meaning all the big corporate for profit as well. So
okay,
tough
so that
comparison.
doesn't reflect just here. So that's why that didn't look quite right. Okay, thank you.
Okay.
Yeah.
This slide or?
Yes, this one.
Okay.
Thank you. So here it says respondents are 101 instead of 102. Did they have the option to answer or not answer questions?
You know what? I didn't.
Yeah, some of the questions, some of the employees didn't answer a particular question.
Oh, okay.
So that may have dropped them out in this category as well.
Yeah, you had options to does not apply or do not want to respond.
Oh, I see. Okay.
But they just moved on to the next question.
Oh, Commissioner Green.
And is there an opportunity for an employee to comment as to what would make him say, or him or her?
There is not a comment section.
Not on the survey. The importance of is the dialogue with the supervisor. That's when we're talking about results and we're talking about here's the crew or the department's results. You know, what do you think are the reasons why on a given question we scored here? That's the dialogue that we feel you have value in. You have start the conversations. That to me is one of the big advantages to doing the survey is you can have a conversation with our employees and say, why do you think we scored like that? But there is no, you just answer the questions in the survey. There's no ability to leave comments. That's the way Gallup's does it and has done it for many years.
Yes.
Nicole, carry on.
Okay. Next slide, please, Tiffany. Okay, so here, this is very similar to just in a different format of the handout you got, just showing the 12 questions and really where the means fell at the bottom. And so to remember, the way the colors are though, is a reflection based on the Gallup overall database, not for us. So I know sometimes it might be, okay, well, 3.7 or 4.18 is a light green, but that's higher than 3.90. Well, that's because it's measuring against all the other organizations and respondents. And so for us, even though it's a high number, it's low compared to what other organizations' means are.
Yeah, example for the first question, I know it's expected me of work. We scored a 4.18. In my book, you know, that's pretty good, but as compared to Gallup's database, it's low. That's why it's got the shading is 25% of the overall database. That's where the category, the darker the color, the better you are in relationship to the Gallup database. But I think it's also, we are government sector, we're not for profit. And we need to also look at, well, the number doesn't make sense to me.
Commissioner Green?
Does last mean the mean from last year?
Correct.
Yes.
So the current mean is this year's score. The previous is 2023. So the last mean is 2023's score. And then obviously the change is the difference between the 2 years.
Okay.
So the areas that we had found that we could improve, like I said, the first one was I have the materials and equipment. I need to do my work right. And for this, as we started to interview employees and gather feedback from this question, it really came down to some simple items like frustrations, like I can't get gloves. Like, why is it so difficult for me to get gloves to do my daily work? And so us working with the shop and, you know, being able to have maybe ready-made kits that, you know, just more supplies available at outside yards. Or there was some frustration with maybe a particular group that we feel we should have 2 graders and we only have 1 grader. Well, that's a little more difficult for us to overcome. But once we had a conversation on why, you know, that's what this sparked, was for us to understand why they were frustrated, for us to be able to explain whether it's the budgeting, letting them know the timeline, letting us speak to them about, okay, maybe renting one for this particular time period or moving resources around. So I'd be curious, I will be curious to see how this improves next year, but that was a lot of the dialogue that it opened up for different areas.
I think just to add to that, it is a snapshot in time. We've said that before, and it's just interesting. Adam can speak probably more clear on this. If there was a particular yard where they were struggling with a piece of equipment that was having maintenance issues, or there was a mechanical issue, there may be some frustration. Hey, we can't do our job if that thing isn't running like it needs to run. And so if we have a down piece of equipment and we are taking the survey that very next week, it's going to be reflective in the scores. So it's interesting because it is that snapshot in time. And as we discuss these things with supervisors, well, there's a story there. And it's important to understand the backdrop in which that snapshot in time is taken. So, and Nicole brings up another good point, and we'll get to this later, is our organization has experienced pretty unprecedented amount of change in supervisors, people retiring. It's been a very big year. And when people are moving into new roles, they are focused in on learning their job, getting the work done, and maybe an area where we aren't paying a real good attention is the relationships of the team. So that may be suffering a little because I'm still learning the job. I'm learning my roles of responsibility and I'm getting work done. oftentimes we talk about, you know, you have to focus on the work to do and the people you do it with, the relationship side. So we may be a little heavy on focusing on the work that to get done, and you may see in my thoughts are that some of our lows are a reflection of the changes that we're going through from a staffing standpoint.
Next slide, Tiffany, please. So that would be, so we have in the last 6 months, someone at work has talked to me about my progress. That was another one that we've had a decrease in, especially a reflection from last year to this year. So some things that even Matt and I have been discussing right now is more of like forward feedback for employees overall. So not just, you know, doing performance appraisals where you're taking a look back at the last year, but focusing more on the today. I know we started that with the stay questions that I presented in my HR update earlier this year, where we're hitting new employees at 60 days to find out how things are going and have that dialogue. It's not, you know, it's not something put in their personnel file, but getting to that forward thinking on where do you want to go? What are your objectives? What's the equipment that you want to learn, and not focusing on what just happened in the past. So we think if we start to move in that direction, that can start to increase these scores as well. Great.
Yeah, I think it's not only that we went down, it was 0.3. So Gallup kind of talks about anything over a 10th, we should be looking at and evaluating. So this one obviously was one of the ones that rose to, hey, there's some areas where we can do some work here.
Next slide. So we'll get to 2 of our high ones to take a look at. In the last 7 days, I've received recognition or praise for doing good work. And this was a high one last year, overall in several areas, how we recognize our employees, and it continues to be. So we have a lot of good practices in place, whether it's the right-of-way awards or ROW awards we do, where employees, supervisors are submitting recognition to employees, and we're doing a drawing for that. Just that, you know, again, we just keep talking about the communication, the transparency, you know, just staying in touch. And it's more, you know, we don't have to be best friends, but just making sure that, you know, how is your day going? What can I do to help and make it a good day? So we're just going to keep on that path. And if anybody has ideas on things to add, I'm always open to that.
Commissioner Green?
Thank you. When you talk about giving recognition or praise, I'm assuming that's supposed to come from the supervisor?
Well, like our recognition that we do, that we post, I mean, yes, I mean, that would be the best and first source. But with our ROW awards that we have, where people are submitting, anybody can do that. So there is a lot of peer-to-peer, whether it's, you know, so-and-so helped me and had my back and looked out for me on this job site. And it's just them recognizing that. So I think it goes up and down and across.
So have you seen Matt's weekly updates where he features who got the right-of-way award and why and so forth? So every week there can be a wave of people who are given the attaboys, so to speak.
That's good.
Exactly. And then the next one that we have that we increased is the I have a best friend at work. So that took some education for people to understand, I think, after the first time, because it feels like a bizarre question. But when we dove down and explained it further, as we've had time over the last year in talking about this and really understanding that it doesn't have to be your best friend, but somebody that you trust and that you can maybe bounce ideas off or confide in, or that you feel like, you know, has your back. And so this was a great improvement, I thought. If you talk to employees, and maybe you'll see this even at the barbecue this Saturday, the amount of relationships that people have outside of work, like, is beyond my comprehend. Like, I don't even realize how strong they are, how many people go together camping and on trips, or their families do things together, or they're biking outside of work, and just all those relationships and things that they've developed here. And we know that how important that is for us here, that it just makes being here a better day at work, that you like the people that you're around, or you have that person that can be your buddy. Next slide. So we did add 4 additional questions at the recommendation of Gallup, and these would be the Q12 plus. And this gets to a higher level of looking more at the organization versus those hierarchy of needs of the employee. So we have, at work, I'm treated with respect. We have, my organization cares about my overall well-being. And these are the first times we had asked these questions. The next slide. I have received meaningful feedback in the last week. And then my organization always delivers on the promise we make to customers, which is probably the one we scored the lowest on. So this just gave us a new avenue of things to discuss and focus on, but they all tie back to the original 12, definitely. So I hope that was helpful. I know that you've had questions and have been curious about how our numbers had come back, and I'm happy to dive into numbers further with you at any time. Or I think a lot of directors and supervisors would have their own stories on how they've used this, how it's helped. We have some that get pretty passionate about it. So
could also add that one of the advantages is you can break it down per department, in whether it be the admin, operations, or engineering, and then further break it down if we have enough participants into the different areas like permits or construction or heavy equipment or state trunk line. So I think it provides a nice resource for supervisors to take a look and evaluate their team itself. But also the goal is to really come up with some department goals and to have these further conversation with crews as we're winding the summer construction season down. The fall is a great opportunity to re-engage and have discussions as particularly our operations department is going through dry run. I know that's the plan to meet, and it's always a good time to meet with crews. So we'll be making the rounds.
Commissioner Yamas?
Thank you. It's very good. And sometimes I think about, is it managing expectations, because everybody feels like they should have a new truck or all the new equipment. But thank you. I was curious about the way you did this, and I appreciate the report.
thank you.
Absolutely.
Commissioner McCollum?
Yes, I think this is very helpful. I'm glad that you do this, and looks like you're keeping on top of it too. So this is good for retention and even getting people to sign on here, knowing that they have this openness and transparency to engage and at work. So, thank you.
Commissioner Green, anything?
Yes, I'd just like to say this tool is great. I think it's useful for determining areas where there could be some improvement, maybe on our part. I'm looking at question 11, where it's asking about
Yeah.
in the last 6 months.
Yeah.
Someone at work has talked to me about my progress. That's something easy that I think that we could do.
Absolutely. And to more intentionally do it. So Nicole and I are talking about ways that we can do that. For example, in our union employees, we do a lot of feedback and check-ins at 90 days, 6 months, and before their come off probation. After that, there isn't really a formal performance appraisal. They get their step increases per the contract, but looking at formalizing a feedback or feed forward, I should say, feed forward, I think that will really keep it simple, but also do it annually so that we are improving and giving having that good interaction discussion about progress of in career development as well.
I would just ask at some point in the future where it's convenient for you to do so, let us know what ideas perked out of this.
Okay.
Right? The conversations that you have, what kind of new ideas or changes in the how arose out of this.
Absolutely.
And the
Thanks
plan
for
is to have another survey go out following April 2025. And then we'll kind of talk about, hey, do we want to continue this practice? Because we had originally signed on with Gallup for 3 years. And we're definitely seeing it's a great system, and whether we want to continue that practices moving ahead. But we're in it for at least another survey in April of 2025.
I remember when there was discussion to do this. And so last year we didn't get results. So it's good to have them this year. And it's turned out to be a good tool. Is that right?
Absolutely. Yeah. I think so. Again, the value to me often is those conversations with employees and supervisors and or even directors where we're sitting in and talking about, let's look at the results. Let's talk about these questions. Let's talk about, what do you think in question 11 about progress? How could we do a better job of that? So to your point, Commissioner, it is definitely, there's value in having those discussions. So definitely good to get the survey results, but even more, those discussions to me are the real value for the organization.
Can you describe what kind of support we have for our foremen and our supervisors who are now supposed to remember to thank people and tell them how great they are and how are you doing today? And that's a lot in addition to the rest of what they're responsible for.
Yeah. So I think there's a lot of different like we come at supervisors a lot of different ways, I would say. There's a lot of like MPSI tied back to this, and MPSI is always a topic at monthly supervisors meetings. And like I said, we always try to touch on Gallup at monthly supervisors meetings as a reminder. Gallup has a plethora of hand-holding in there. They send, communication update emails, whether it's articles or action items, or steps that an employee can take. We have, with Absorb coming on, there's a lot of leadership or different types of trainings that they'll be able to do and participate in online. So I would say all of those resources.
Yeah, just a reminder, MPSI is Michigan Public Service Institute. That is our training platform for a lot of our areas. So, but particularly our supervisors have, over the last 10 years, we've got a large percent of our supervisors. It's a 1-week course for 3 years. So 3 consecutive years, you go to this 1-week course, and then you become an MPSI graduate. Over the course of that week, they cover a variety of topics in balancing work and relationships, those kind of discussions, the far-ranging topics. And it's been a tremendous resource for helping to train and support our supervisors. So, but another one is, as Nicole mentioned, we're launching the WCRC Academy, which is the Absorb online training system, where we can put our own content, but also they have thousands of courses that we can take advantage of, whether it be technical or professional development. But more to come. There'll be a working session probably first quarter to talk about that WCRC Academy.
I just worry about the foreman. They've got the people who are doing the work and then they've got the residents that are complaining and they're stuck right in the middle.
And I think Matt had mentioned that even early on, even I think it's a lot of supervisors, not just the foreman, you know, like in engineering where they've taken on this new role and they're trying to do their work. And then suddenly they have all these people to manage and maybe they're newer at being a supervisor. And so that's easy to get away. It's this is also, I think, you know, it's not easy to hear the areas that you're low in, but it is good. And it's nice to see the areas that we're succeeding in. So to have those reminders as well and give ourselves little pats on the back and then get into what we can do better. So
one question.
Commissioner Yamas?
This goes to everyone, right? Staff, union and non-union, right?
As far as the results?
Yeah.
Yes, we need to, this is a great example. I'm not sure we've rolled that out to everyone, but now that we have email for everyone, we can absolutely, we're starting by, in our supervisors meeting, we're gonna go through this presentation. Results have been shared and reports have been emailed to supervisors, but we haven't rolled out, I don't think, results to every employee, a document saying, here are the results, but this is a good, what we handed out would be my intent.
yeah,
I didn't mean the
supervisors have it.
results to everyone. I meant, does everyone take the survey?
Yes.
Yes.
They have, everybody has the opportunity to take the survey, and that's where we got the 102 this time, which was a good number. But everyone has the opportunity to take one, whether it be you work in admin, operations, or engineering, the whole organization.
Thanks.
Thanks, Nicole.
Okay, thanks.
All right. Mr. McDonald, anything else?
That concludes our agenda.
All right. A motion to adjourn, please.
So move.
Or Ms. Aaron?
Commissioner Joya McCollum.
Yes.
Commissioner Rod Green.
Yes.
Commissioner Gloria Yamas.
Yes.
And Commissioner Burkholder.
Yes, we are adjourned. See everybody back at 1 o'clock.